Thank you, Nathan. So tonight's webinar is titled What to Expect in Housing Court. And there are so many aspects to the New York court system. We know it can be overwhelming to tenants, whether you are currently in court or not. This webinar will be extremely helpful and resourceful. We have a special presenter, Abigail Unger, staff attorney at Palante Harlem. We are very happy to have Abigail with us and on our team. And she's here, and they are here to give everyone the aspects and the information about housing court. Please place all questions in the Q&A box and it will be answered accordingly. And I will now hand it over to Abigail to start the presentation.
All right, thanks so much, Jakari. Good evening, everyone. I'm Abigail Unger. I use they, them pronouns, and I am the staff attorney at Palante Harlem. I started working in housing court in 2021, shortly after I graduated law school, and I've certainly learned to expect a lot of things. So I'd like to just as Jakari said, housing court can be really overwhelming for lawyers, let alone people who are not lawyers. So this presentation, I'm just going to try to break down a lot of the things that go on in housing court. And it's going to be a more general overview. A lot of the specific topics that I touch on are things that Palante has other webinars on and other material about. And I highly encourage you to check that out because they're very informative. So let's go on to the next slide.
Also, one more thing, Abigail.
Oh, yeah.
We'll have a Q&A open once Abigail is done presenting. So just place your questions there. Thank you.
Great. So every borough has a housing court. It's where landlords bring cases against tenants, and tenants also can bring cases against landlords. The New York Courts website has a list of the phone numbers and addresses of housing courts. It's at that address. This presentation is going to be also available later, so if you need to pause it and copy it down, go ahead. Next. So housing court is the biggest court the biggest and busiest court system in New York by far. In 2024, there were 177,000 active eviction cases. Housing courts in the resolution parts regularly hear 40 to 50 cases a day or more. Your landlord's attorney and your attorney will also have many other cases that day, often in other courtrooms. If your case is adjourned, your next court date is probably going to be in 6 to 10 weeks, unless there's a situation like you've been illegally locked out or you've received a notice of eviction from the marshal. So housing court is busy. Housing court moves kind of ponderously and slowly, but in some ways this is to your advantage as a tenant. It does take time to get things done in housing court, and your landlord is not going to be able to kick you out of your apartment on the first appearance. You have more time. Let's go to the next one. So most cases in housing court settle without a trial. Settlements are often these things that we call stipulations. You often just write them up in the hallway outside the courthouse, and later they get uploaded to a website called NYSEP, stands for the New York State Electronic Court System something. I don't remember the acronym off the top of my head, but it's a very useful website because you can actually look up all the files on your case on that website. They're all going to be available there. The parties in a case, and parties just means the two people on the opposite side of the case, or in most housing court cases, the corporation on one side and the tenant on the other, can really settle at any time, including in the middle of trial, which I have been privy to. Judges, lawyers will encourage you to settle your case. You're not required to. You can choose always to go to trial instead. Trials have their own risks, and depending on your case, you may or may not get a worse outcome at trial than you would in a settlement, it all kind of varies. I'm not answering questions right now, am I, Jakari? I'm just doing presentation first.
No, but we could probably stop halfway through and answer a few.
Okay, sure. Next case, or next slide rather. Going to court. So these days, almost all housing court appearances are in person, not virtual. If you have a disability or health issues and you can't appear in person, you can email the court at ada@nycourts.gov and ask for an ADA accommodation to appear virtually. If you have a lawyer, they can appear in court for you, but please tell your lawyer in advance whether or not you're going to be there to save your lawyer some confusion and heartache. If there's an emergency and you absolutely cannot make it to court, you should let the court know as soon as possible. Just call the clerk's office or call the housing courtroom that your case has been assigned to, and let them know immediately. If those things aren't, if none of those apply, then you really, I cannot stress this enough, be at the courthouse. If you need to take time off work or if you need to take childcare, like plan that early. Don't wait until the last minute. Okay, next slide. So housing court proceedings are in English. Court interpreters are available if English is not your primary language, but be aware that interpreters are in pretty high demand and short supply. Consider bringing someone with you who is fluent in English and can interpret for you. Also, if you do need an interpreter, just try to request that and make that known ahead of time as soon as possible. You can also call 646-386-5670. And that's the hotline that the court uses for requesting translators. I would particularly recommend doing this if you speak a language that's not as common in New York City. Like you can usually find, like almost every borough will have Spanish translators, Mandarin, Russian pretty readily available, and you know, other majority languages spoken in that borough, but not every language is going to have an interpreter at court that day at the same time. Next slide. Housing court's a waiting game, but be on time. The lines for housing court are very long, especially in the morning. Get there early. Once you're inside the building, find your courtroom. Most courtrooms are going to have a bulletin board outside the door where there's a numbered list of the day's cases. Look for your name on the list, write down the number next to your case. Then you want to go into the courtroom, look for the security officer, and tell the officer your case number. If you need an interpreter, now is the time to ask for one. And be on, as much as you can, be on time. If you are more than 30 minutes late for a court appearance, you will likely be defaulted and your landlord can get a judgment against you. You don't want that. Just general like things to keep in mind inside with courtroom behavior. Have conversations in the hallway, not in the courtroom, unless you're talking to a court officer. Turn off or silence your phone. Just in general, don't wear anything or say anything that you wouldn't in church or synagogue or mosque or a library. That's just kind of the general rule that I give people. When you're in front of the judge, you want to wait your turn to speak. Talk directly to the judge, not to the landlord or their lawyer. And judges are usually addressed as Your Honor, or you can also just call them Judge. They like being called Your Honor, though. It makes them feel good. If you have questions, when you are in court, you should ask them. Absolutely. Okay. Types of case. There are a lot of, okay, see, there's a lot of questions. I might pause after this to answer a few. Types of cases. So both landlords and tenants can bring cases in housing court. Landlords will typically be suing tenants in non-payment and in holdover proceedings. Tenants sue landlords in HP actions. Next slide. Non-payments are the most common type of case in housing court. Like, I think it's somewhere between 80 to 90% of cases are non-payments. So that is what this presentation focuses on a little more heavily. These are cases where the landlord is claiming that you, the tenant, have not paid rent. Landlords are asking for two things in these cases. They'll be asking for a money judgment, which is the money owed to them for the rental, for rental arrears, which is the past due money that they are claiming is owed, and a possessory judgment, which is evicting the tenant. However, in these cases, like typically what the landlord really wants is money. They don't necessarily want to evict the tenant, they just want to be paid. Next one. Holdovers are different. These are cases where the landlord is claiming that the tenant doesn't have a legal right to be in the apartment at all, like whether or not you were paying rent. The landlord's main goal in this case is to get the apartment back. They're not. It's not as much about the money. I mean, sometimes it is still about the money, but their primary goal is getting the apartment back. Usually in these cases, so they will be asking for a possessory judgment, and sometimes they will also ask for use and occupancy, which is another word for rent. But it's not a money judgment unless the landlord specifically asks for it. Next slide. Landlords can start a holdover case for a lot of different reasons. The most common ones are if you're a licensee. That means you never signed a lease with the landlord. The tenant of record was letting you stay in the apartment, but the tenant of record is no longer living there, either because they moved or passed away. So now the landlord is saying you don't have a right to be in the apartment because I don't have a lease agreement with you. Expired lease is exactly what it sounds like. Your lease expired and you didn't renew it. Breach of lease can be a lot of things, but it basically, if you didn't comply with an important term in your lease. And these are usually about like important terms. So some holdovers believe there's what's called nuisance cases, and that's when the landlord is alleging that you're like disturbing the peace and quiet and enjoyment of your neighbors. All right, next slide. Then there are HP actions. HP actions are typically brought for repairs, which is when the landlord has not fixed unsafe conditions or provided essential services like heat and hot water. You can get an order to correct, which is when the court orders the landlord to make repairs. Then if repairs aren't done, the landlord might have to pay a fine. There's also harassment that you can bring in HP actions, which is a pretty complicated topic, but basically if the landlord is using illegal tactics to get you to leave your apartment, or using illegal tactics to kind of interfere with your ability to use and enjoy your apartment, that's harassment. I'd love to do a fuller presentation on that, but that is a very long topic. All right, next slide. So the steps, so cases have different steps and they go different ways. Before the case even starts, you always have the service of either a rent demand or a notice of termination. Then the case starts. You get served with the court papers, or you serve your landlord with the court papers if you're filing an HP. If you get served with the court papers and you file an answer, then the case goes to a resolution part, where a bunch of different things can happen. It may or may not get sent down to the trial part. If you don't show up, then a default judgment can be issued against you. This is just kind of a diagram, and I'll get into more detail with it later. All right, I'll just answer some of these questions now just because there's a lot. The most effective way to present evidence to the judge, and how far back should it go?
Abigail.
So if you're in a trial, what we call a trial part, and in front of a trial judge, different judges will have different rules of evidence in their courtroom. They'll have different ways that they want you to present it. I would say if you're representing yourself as a lawyer, usually the court will be fine if you kind of email them the documents beforehand. If they're files like videos or photos, like if you upload them somewhere and then email them the link to that, or bring it in on a flash drive. As far as how far back the evidence should go, it depends on what you are trying to argue with that evidence. If you're trying to argue, for example, that you've been paying rent and that the landlord is claiming rent that you don't actually owe, you should present evidence back from the time that the landlord says you haven't been paying rent. If you're trying to, yeah,
Um, I'm gonna read the Q&A for the next question.
what?
I'm gonna read. I'll read the questions for the Q&A for the next one.
Okay. Oh, sorry. Um, so the so if you're trying to argue that your landlord illegally deregulated your apartment at some point, then there's different laws about how far back you can look with that. This is one of those cases where honestly you should talk to the court attorney and ask them what kind of evidence they want you to present, how they want it to be given, and how far back they want you to go. If you're representing yourself, just like ask the court attorney those things. They'll usually set it out for you. All right, I guess I can do like two more questions now. I guess.
Two more. So the next question is from Kimberly. Good evening. I'm currently in court for a pending eviction stating holdover. I'm not the primary tenant my family was, but he is deceased as of 2024. Spoke to the legal aid and was to proceed with succession for the apartment and to see if I am given a lease. Is this correct?
Yes, this sounds like a succession claim. So we have another webinar on succession that I would suggest checking out. But basically, succession is that if you are a family member or you have a familial relationship with a tenant, that you've been living together with them for at least 2 years, and then that tenant no longer lives there either because they passed away or because they moved out, you have a right to succeed, to sort of take over their lease under their name, under the same terms and conditions, if you're in a rent stabilized or rent controlled apartment. So that is correct. I don't have time to go into succession is also a very long topic. So to find out more about that, I would suggest looking on our website or on Housing Court Answers to get more information about what succession is and what kind of documents you need to prove your case.
Thank you, Abigail. And then the next question, and we're going to go back to the presentation from Javier. I won a holdover case and definitely know it was because I am the president of the tenant association. I am in a case now for a non-payment, which I have an escrow, refusal of rent stabilized lease. Can I introduce videos as evidence and how?
Yeah, you can introduce videos as evidence. Again, this kind of depends. If you're in the trial part, like I mentioned earlier with the first question, the trial parts have different kind of rules about how they want you to present evidence and things that they want you to do. So I would sort of check that. With video evidence, I would also just suggest, for the sake of kind of the court's patience, get to the good stuff, get to the stuff that's most directly relevant to your claim. If you need to sort of, don't introduce like a 24-hour video if not everything, if there's only like 10 minutes where something important happens. Try to just trim it down to focus on the relevant part. And other than that, yeah, check the rules for the part that you're in and check with the court attorney about how they would like to receive that evidence. All right.
We're going to jump back into the presentation.
Yep. Let's jump back in. So next slide, before the case. So before your landlord starts a court case, they need to give you written notice. For non-payment cases, that's a 14-day notice of rent demand, at least for rent-regulated apartments, but now it pretty much applies to most apartments, even if they're not rent-regulated. Holdovers, the amount of the notice they have to give you kind of depends on their reason for bringing the case and how long you've lived in the apartment. This is also called predicate notice because it's notice that sort of is required or necessary for the landlord to bring a case against you. All right, next one. So a 14-day notice basically looks something like this. A rent demand has to include the months you owe rent for and the amount of rent you owe for each month. They can't just give you like a lump sum and say you owe this much rent. They have to break it down. This is not the start of the court case yet. Your landlord has to wait 14 days from the day you receive the rent demand. If you can't pay the overdue rent within those 14 days, your landlord can start a court case against you. Of course, sometimes landlords have been known to send 14-day notices when people don't actually owe money. If that is the case, get copies of the payments you made for the months in question, whether checks, money orders, digital receipts if you paid online. Send them to the landlord through certified mail, because then you have proof that the landlord received it, with a letter explaining to them that you have paid your rent. I know that different people have differing abilities to do that. However, if you are able to pay your rent with checks or with cashier's checks, those are a lot easier to make copies of and keep track of than money orders are, and definitely easier than cash. So a notice of termination is what landlords will send before starting holdover cases. The notice has to say why the landlord is ending your tenancy. In this case, in the one example I showed here, this is a case where the landlord is ending the tenancy because, according to the landlord, this tenant did not sign a renewal lease after it was offered to them. Under the 2024 Good Cause Eviction Law, many landlords now actually do need a good reason to end your tenancy. Before the passage of that law, if you were a market rate tenant, landlords could basically just decide that they wanted you out for no particular reason. If your lease was about to end, they can't do that. They can't just do that anymore. There are some buildings that are still accepted from this law, but as a general notice, it does expand protections in a pretty big way. All right, next slide. So when the case begins, I wanted to get little Law and Order sound cues for these, the little bum, but I couldn't figure out how to do it. The petition. So after the notice period ends, your landlord can start a court case against you. You will be receiving both a petition and a notice of petition. The notice of petition tells you the time frame for responding to it. The notice will also give you the address of the clerk's office where you can give your answer in person. So this is what a petition for non-payment of rent looks like. They are often written in like really, really tiny text, like crammed onto one piece of paper. They can be hard to, and they can be a little bit hard to read. So I'm going to break down certain parts of it that you should like look out for and double check. Next slide. So you want to look for language about this. This is about when they're talking about you. You are called a respondent. If your landlord is suing you in housing court, they are called the petitioner. It's really kind of the same thing as plaintiff and defendant. They just use different words. So this is about respondents are in possession. This will say that the respondents are in possession of the premises pursuant to a written lease, where you promise to pay however much in advance on the first day of each month. This is an important part to double check. You double check who's actually named on the lease and make sure that everyone named on the lease is named in the petition. You want to make sure that you do actually have an active lease with your landlord, or because if it's expired, they can't bring a non-payment case against you because there's no lease agreement. And then also make sure that the monthly rent amount that they're claiming on the petition is actually the correct monthly rental amount. Basically, if the answer to any of these questions is like no, then you may be able to get your case dismissed. Next. Also, with a non-payment case, look for the breakdown. The landlord, again, with both the petition and the notice of the petition, has to break down has to not just provide a lump sum, they have to show how much money, they have to say how much money you owed and which months you owed it for. And again, these are things you want to check whether you've paid some or all of your rent for the months listed in this petition. Something that happens relatively often is that landlords will not actually apply rental payments to the date you made them. They'll apply it to like your arrears or your really old rent if there was a period of time where you like weren't able to pay rent. So that's something that I see fairly often. It is something they're not supposed to do. It's something they do anyway, but it is a possible way to get your case dismissed. If also, is your landlord asking for rent that should be paid for by a subsidy, like a shelter allowance, or if you have screening? Again, if the answer to any of these questions is yes, you may be able to get the case dismissed. Next. Also, take note whether if your apartment is rent regulated, the landlord must put that information in the petition. Tenants of rent regulated apartments have special legal rights. In NYC, rent stabilization is the most common type, but there are other ways too there are other forms of rent regulated buildings. Again, I believe we have presentations on many of these types of housing and some of the rights that tenants in those types of housing receive. Again, it's a very long topic, so I'm really not going to be able to go over it in this presentation, but the information is out there. And if you do have rent regulated housing, you should absolutely check that material out to learn more about what your rights are. All right. Service. So the landlord needs to serve you with the predicate notice and the notice of petition. Most of the time, landlords will hire a process server to do this. Technically, anyone who's 18 or older and isn't part of the case can serve someone with court papers, but most of the times landlords will just use process servers. The server has to personally deliver the messages to you at your apartment, which is called personal service. But they can, however, also give the papers to another adult who lives there with you, which is called substitute service. The server needs to make 2 attempts to serve you in person. 1 attempt has to be outside normal business hours because the reasoning is like a lot of people just are not home during 9 to 5, they're working. And they have to make the attempts on different days. If by the 2nd attempt no adult has answered the door, they can use conspicuous service, or it's kind of called, or you may have heard of it as nail and mail, where they tape the papers to your door, slide them under the door, and then they also mail you a copy. All right. I'm going to do this section, and then I think, yeah, I'm glad we have so many questions, but I think after this one, I'm going to do like three or so more. All right, answering the petition. So from within 10 days of the date the petition was served, like you received it, you should answer it. In your answer, you can raise defenses to your landlord's claims. Defense is basically a reason why your landlord shouldn't evict you or why you shouldn't have to pay all the rent due. If you can give your answer in person at the clerk's office, and the clerk will write your defenses on the form and give you a copy of that form. Usually when you answer is when you get your first court date. The date, time, and room number will be printed on the form that is given to you, and the court date's usually like a week or so later. If you don't answer, sometimes the court will just set a date after a certain period of time, in which case usually the court will mail you a notification that like you have to be in court on this day, this is what's going on, please file an answer. So, but those messages have a tendency to get lost. Sometimes they're just like on little postcards. All right, next slide. So this is the form used by the clerk's office. And it has most of the most common defenses that tenants raise in housing court. There are other defenses that aren't listed on this form, but many of those defenses are very legally specific. They're about whether your landlord has followed certain laws. They're hard to spot if you're not a lawyer. Sometimes they're hard to spot if you are a lawyer. Most of them, I think, most of the answers here are pretty self-explanatory. There's service, which we just mentioned, that either you didn't receive the papers or you received the papers in the wrong way. Like the process server said, oh, I visited you, but no one was home, but actually at that time you were home. There's parties, which is about that either you're not properly named on the lease, that sometimes the landlord will be suing a dead person, which they can't really do. Sometimes the petitioner isn't actually the landlord or the owner of the building. Sometimes maybe the building is in foreclosure. So the landlord is not really the one who has the right to collect the rent, that's the receiver. There are different defenses about rent. There are different defenses about rent, about whether you were properly asked, whether the rent you gave the rent and it was rejected, the monthly rent wasn't the legal amount, and maybe your landlord overcharged you. You paid part of the rent to the petitioner already. The apartment, this is sort of about if there's, this is where you have like conditions in your apartment that are dangerous and hazardous. Maybe the petition is describing the wrong apartment. Maybe they sent you someone else's, maybe they sent you someone else's petition. Or actually like this is illegal, this is being used illegally. General denial, I just want to point out in the other, is just sort of you generally saying no to everything that the petition says. It's usually good to check that one off, but a lot of times if you look at these answers and you recognize that certain of these things, you're like, hey, yeah, that's true. I did try to pay my landlord rent, but he said, I'm not going to take it. Then you should check off the specific ones as well. Right, next slide. Just a couple other tips. If you are raising a defense about service particularly, you want to provide specific details beyond just like, it wasn't correct or I didn't get it. So for example, you can look at, so process servers, for example, have to fill out an affidavit after they serve you. That affidavit has to say like, when did I visit, and what happened when I visited. If they say, oh yeah, I visited on March 18th at 6:30 p.m., but no one was home, and you go, hey, wait, no, I was home on March 18th at 6:30 p.m. and no one knocked on my door, you want to mention that specific fact. Also, you want to bring up things like any DHCR orders for your apartment, if there's a rent reduction order or a rent overcharge order. If you've brought any cases against your landlord in court or at an agency like DHCR, the Commission on Human Rights, and any HPD violations for your apartment or building. Right, next one. Other things is, it is, one thing to know is that it is illegal for landlords to evict you as retaliation for you exercising your rights as a tenant. This includes calling 311 about conditions in your apartment, participating in a tenant organization, suing your landlord in an HP action, even just like telling your landlord or super that they violated health and safety laws. If your landlord brings you to court within 1 year of you doing any of these things, there is an assumption in the law that the reason your landlord is doing it is to retaliate against you. This is true even if your landlord is taking you to court because you owe money. The presumption exists even then. If your landlord cannot prove that there was a valid reason to take you to court, then your case will be dismissed. Right. So before your first court date, you should prepare. Bring copies of important documents with you, like your lease, or if your lease is expired, the most recent one. If you've made rent payments, bring proof of that. Bring copies of checks, money orders, things like that. If you receive a shelter allowance or a subsidy like FEPS or City FEPS, you can request a benefits report from HRA. That benefits report will actually show whether HRA has been issuing checks and your landlord has been cashing them. If you have SCREE or DREE, get a copy of a renewal letter showing the amount that your rent is frozen at. Get pictures of any conditions in your apartment. And if you've had a written communication with your landlord or super, like as emails, letters, or text messages, get that ready too. Also, you can research your building. There's a lot of publicly available information about many buildings in New York. The following these websites, Who Owns What, Displacement Access Portal, and HPD Online, are great places to start. They can tell you a lot of things, including the rent regulatory status of your apartment, what kind of violations there are for your apartment, who really owns your apartment, who's the person behind all these weird tiny little LLCs and stuff like that. So So that's a very useful website. Right. If your apartment is rent regulated, you can also get a copy of your history from DHCR. You want to look up the address and phone number for your borough's Office of Rent Administration, and make an appointment with them to get a copy of that history. The reason you want to do this is that landlords have to register rent regulated apartments every year with DHCR. And this registration includes a lot of information, including who the tenant of record is, the regulatory status of the apartment, and the maximum legal rent. I just had a case, for example, where the landlord was claiming that an apartment was rent controlled, but had been registering the apartment as rent stabilized and giving the tenants rent stabilized leases. They really wanted to deregulate the apartment because it was like very big and $490 a month. But the DHCR report showed us what was going on, and it helped us get what we wanted in the case. All right, next one. This is actually, I think, a biggie. Just know what your own goals are and then make a plan according to that. Do you want to stay in your apartment or do you want to move? If you want to stay, can you afford the ongoing rent? If you want to move, how much time do you need to move? Do you need repairs? Do you owe rent? And if so, is the money saved or do you need to apply for one-shot deal or charity assistance? Next. So for example, if you want to stay in your apartment, then generally, unless there are very serious warranty of habitability issues or rent impairing violations, you should really consider paying ongoing rent to keep your arrears from getting even higher. If you're planning to move, then it makes a lot more sense to just save the money. Or at least that's the way I usually think about it. If you do need a rental subsidy, you might be eligible to receive one, but you will need to put in a fair amount of legwork with different agencies, go through an application process, and then be on them as they process your application. If you're planning to move, remember that finding affordable housing is not easy. You will need more time to move than you think you do. You just will. If your landlord hasn't made repairs, you can ask for a rent abatement potentially. If you haven't called 311 yet, then you should definitely do it as soon as possible. So there are also HPD records of violations in your apartment. If you do decide to settle your case, make sure you include repairs in that settlement. If you want to stay in your apartment and you owe rent, and you actually do owe rent, then you do need a plan for paying your rental arrears. You can get rent abatements, but 100% abatements, like where you owe no money at all, it is very, very rare for the court to grant that. Pretty much like the situation has to be, it's like it's so bad in your apartment that you are no longer living there. So just be prepared that even if you do get an abatement and the judge says, okay, we're going to knock 30% off the money that you're owed for rent, you still are going to owe the remaining 70%. So if you're withholding rent due to repairs, you can do that, but put that money in a savings account and do not touch it. If you have that money, you have a lot more bargaining power. If you spend that money, now you're kind of on the back foot as a tenant, trying to get the money rather than focusing on like the real issues with your apartment, which are the repairs. And if you need help from HRA or charities, start getting materials ready for your application ahead of time. All right, next one. All right, I think I'll answer like 3 more questions now.
Okay.
Okay.
We have one question. Am I still required to pay rent if my apartment is in bad condition?
So we actually just kind of talked about that. You can withhold rent. If you do but again, like my recommendation is that if you withhold the rent, just put it in a savings account, don't touch it. And that way you have it for later and you might not even end up having to pay all of it. But yes, you can withhold rent, that's your right. But if you do withhold it, just hold on to it.
Okay.
How do I appeal a housing court decision? I'm going to talk about that at the end of the presentation a little bit. The short answer is that you need to take the decision to the appellate term. which is the court that's sort of a level above housing court.
Okay. What if
If your landlord violates a court order, you can bring them to court for contempt, which I will talk, which I can talk about a little bit more at the presentation, after the presentation rather. But yeah, if they do violate a court order, then they may have to pay a fine. They may have to pay a fine to the city. They might have to pay penalties to you. If it's bad enough, they might even end up in jail. So yeah, bring them back to court for contempt if they violate a court order. If you miss your court date, oh, sorry, this next question, I guess, and then I'll go back to the presentation.
what happens if I miss my court date?
If you miss your court date, there is a risk that you will be defaulted, like I mentioned earlier, and that the judge will just enter a judgment for the landlord. If you miss your court date and you know you missed a court date, go to court as soon as you can, explain what happened, go to either the court attorney or go to the help center and you're going to want to ask to vacate if there's a default judgment against you. So just act as fast. If you know you've missed a court date, act as fast as you can, I would say. Because the longer you wait, the more complicated it might get to challenge any kind of order that got issued against you.
Okay.
All right. So on your first appearance in court, so housing court has two different kinds of courtrooms, broadly speaking. There are resolution parts and there are trial parts. Resolution parts don't hold trials. Instead, they're kind of there to encourage landlords and tenants to resolve their case with a written agreement. We call those stipulations or STIPs. Most landlords do not go to court in person. You will meet with their lawyers instead. You will probably be meeting with them in the court hallway, which is crowded and noisy. Your landlord's lawyer also probably has cases in other courtrooms and may just vanish on you and not reappear for a while. If you have to leave court by a certain time and you can't find the lawyer, talk to the court officer, and like a lot of times they will call the lawyer for you, which is very nice of them. Next page. Ask for right to counsel on your first appearance. If your household income is less than 200% of the federal poverty guidelines, you may qualify for a free lawyer. I listed the ones for 2025 here for a 1-person and 3-person household. You can also just Google this information and you'll find out what 200% of the guidelines are. Do it on your first court date. In a lot of boroughs, they have implemented kind of a silent rule of like, if you don't ask on your first court date, they just don't do it. Some court attorneys will still ask you if you want a free lawyer. Not all of them will, so make sure you're proactive and you ask. You can also call that phone number for a right to counsel referral. Every borough has several legal service organizations who provide right to counsel services. Different organizations staff the courthouse different days. However, next slide. Legal service providers simply, at this point, just do not have enough lawyers to represent every eligible tenant who gets taken to housing court. There are a lot of reasons for this that I could talk about for a very long time, but to keep this presentation focused, I will just say that in March 2025, only about 30% of tenants who had their first court date were able to get a lawyer. If you don't get a lawyer, you may still be able to get legal advice from lawyers who are in the courthouse. If you get legal advice, however, that does not necessarily mean that the lawyer is going to represent you. You can also ask the court to reschedule your case and give you time to find a lawyer. I've linked a website there that lists all the right to counsel providers and law offices that provide free legal help to tenants. I used to do right to counsel work myself, and there's a lot of very talented and passionate people doing this work, but the demand is overwhelming and the city does not supply us with does not supply lawyers with nearly enough of what they need, which means the tenants don't get nearly enough of what they need either. The landlord's lawyer is not your friend. They do not work for the court. They work for the landlord. They are always going to try to settle cases that are in ways that are good for the landlord. That doesn't mean it's going to be good for you. Some landlord lawyers will just not be upfront about this fact at all and will either not mention who they work for or let you kind of assume that they are working for the court. This particularly happens, I see, when there are language barriers, tenants whose first language is not English, and landlord lawyers exploit that fact to confuse them, which is scummy and bad. If someone does approach you to talk about your case, ask them who they are and who they work for. Some lawyers are bullies. They will try to intimidate you. I have had landlord lawyers rip up stipulations in front of me, and I'm a lawyer. So they might threaten to take you to trial if you don't sign a stipulation. They might get in your face and shout at you or tell you that, like, it's impossible to do this thing that you want. If a landlord's lawyer is acting like that, go right to the court officer, tell them what's happening, tell them that the lawyer is intimidating you, and that you want to talk about your case in front of a court attorney. The court attorney will be there as kind of a third party to and they will often just help keep that landlord lawyer in check. And when they start to say something ridiculous, the court attorney will be like, "But you agreed to do it in this other case," and they might back down. If you and your landlord are not ready to settle the case, I'm going to talk more about settlement in the next slides. You're going to get an adjournment, which means that you're going to get a new court date in about 6 to 10 weeks. Adjournments give you time to review anything your landlord sends to you, send documents to your landlord, get advice from a lawyer, file something called a subpoena to get government agencies to give you documents, get a court-ordered inspection of your apartment if there's repair issues, and pretty much do anything else you might need to do for your case. All right, next slide. Settling. So like I said, the vast majority of cases do get settled by stipulations. A stipulation is a written document that describes what you and your landlord are both agreeing to. If you don't have a lawyer, the judge is required to review the stipulation with you in court. That is really your last chance to ask questions before the stipulation becomes final. Whenever you are talking about your case with anyone, repeat your defenses. Even if you've already raised them in your answer, just say it like a broken record. Next. So stipulation, what's in a stipulation depends on the case. In non-payments, it's usually how much you owe with a breakdown of back rent, when you have to pay, which could be all at once or in installments, any demands that you have, like repairs, a renewal lease, recertification paperwork, and consequences if you and your landlord don't do what was agreed upon. This I cannot say enough. Do not sign anything. Just don't sign anything until you understand what you are agreeing to. Slow down, read everything, ask questions. The landlord's lawyer might try to hurry you along. Don't let them. You can also wait to sign a stipulation until you've reviewed it with the judge or court attorney. You can hold off on doing it until then. The landlord's lawyer may say, "Oh, nobody does that," but people do that. That's totally normal. Remember, just stipulations are legally binding, and you can face serious consequences for not following its terms. So you want to make sure you understand those terms. So a stipulation can be handwritten, or a lot of times, especially with tenants who represent themselves, which we call pro se, the landlord's lawyer will just have a form that they printed with all the terms they want to include. These forms often have terms that are very bad for tenants. These are some bad ones in particular that you really want to watch out for. And honestly, if you see them printed on that form, just cross those phrases out. Just cross them out. Final judgment for petitioner or warrant to issue forthwith. You don't, upon default in any payment due, the amount the entire amount shall immediately become due. That's called an acceleration clause. You don't want it. Time is of the essence. That means that even if you're a couple of days late paying, your landlord can still say, well, you defaulted and I'm going to evict you. You don't want that. All monies shall apply to current rent for arrears. That means that that means that your landlord will not be applying the payment to what they're supposed to. You don't want that. Legally, you can't make promises about paying rent that's not yet due because it doesn't exist. So if they're like, oh, well, we want you to, if it's June now and they're like, well, we want you to agree to pay July's rent by whatever date, like legally, you can't actually do that. That's not enforceable because you're talking about the future, about something that doesn't exist. Landlord will inspect and repair if necessary. No, if the landlord needs to inspect and repair, you list exactly what those conditions are, and you set access dates for when the landlord has to send people to come there and fix what's wrong. Next. Double check the numbers. If you do owe rent, make sure your landlord is not asking for more than what you actually owe. You don't need to pay late fees, legal fees, or additional charges. Break out your phone calendar and do the math yourself about like what your rent is for any months that you owe. And if the number you come up with is less than the number they've written down, point that out. Also make sure that the number you agree on reflects your share of the rent. If part of your rent is subsidized, the government's responsible for paying it, not you. So if you get a certain portion of rent covered by shelter allowance every month, the landlord doesn't get to double dip and claim that rent both from HRA and from you. Also, just watch out if your landlord offers you a backdated lease, because they will try to retroactively increase your rent more than they're allowed to. That's probably a whole topic we could also get into for another presentation, but for right now, just watch out for anything that's backdated. Also, push for what you want. A stipulation is an agreement between you and your landlord. You also have the right to set terms. This is a lot easier to do when you do come in with a plan and with evidence to back up your claims. So just come to court prepared. It really helps if you're able to just point at something. If the landlord's lawyer is speaking nonsense and you can just like point to something, then that's a very effective tactic at getting them to stop speaking nonsense, especially if you do it in front of a court attorney or judge. Also, if your landlord promises to do something, or if the landlord's lawyer says, oh yeah, he'll do this, he'll come by and do repairs, write it down in the stipulation. A verbal promise is worth the paper it's written on. Things you can ask for include a zero balance rent breakdown. You should always ask for that. You can ask for more time to pay or move than the landlord wants to necessarily give you. You can ask for repairs for conditions in your apartment, be really specific about what those conditions are, and then write down the dates you can provide the landlord access to fix them. You can ask for rent credit or rent abatement in exchange for you dropping some of your own claims, like warranty of habitability or a rent overcharge. If you're applying for rental assistance, write that in the stipulation and add that the landlord is agreeing to provide you any documents necessary for that assistance. That way the landlord can't like come calling surprised about like, oh, why is this being so slow? It's like, you know, I was working with HRA and you were supposed to give them something and you never did. Be very careful about agreeing to a final judgment and warrant. If you keep those words in the stipulation and you can't pay when you said you would, the landlord can hire a marshal right away as soon as that date happens and serve you with an eviction notice. This is better. This is language you should use instead. It's just that what this language basically means is that the landlord doesn't automatically have a warrant and can't automatically start eviction against you the day after you miss a pay date. The landlord has to go back to court and ask the court for a judgment and a warrant. If you missed a pay date on a previous stipulation, or if your case has been sent out for trial, you might not be able to avoid a final judgment. But if this is the first time you're agreeing to pay something, don't agree to a final judgment. If the landlord's lawyer throws a fit, get the judge or court attorney involved. Because, I mean, again, when tenants are represented by lawyers, landlords will do this all the time. They will not agree to a final judgment on the first step. But they'll try to do that with tenants who are on their own because they're scumbags. Should I say, am I allowed to say that?
I'll say what you,
Okay. All right. Next slide. Actually, I should probably answer maybe 3 more questions now.
let's get through it, to the full presentation. It's already 8, so let's just try to get through it. And then
let's get through it, and then I'll just do everything at the end. All right. So trials. If you and your landlord cannot settle the case, you will be sent to trial. First, the judge or court attorney will send you to another courtroom, which is called the trial part. In the trial part, you will be assigned to a trial judge. The trial judge will set a date for a pretrial conference that's usually about 3 or 5 weeks. At the pretrial conference, you and the landlord are again going to try to settle the case. The judge and the court attorney are going to be like, can you settle the case? If you can't settle the case, which happens, you and the landlord will come up with a list of facts that both of you can agree on. So, for example, you might be like, okay, you know, my landlord does not have to prove that they are the owner of the building. I just agree that they are. We just agree that the apartment is rent stabilized. There's not really any point about arguing about that. And if you can't settle, then the case goes to trial. At trial, your landlord has to prove that everything they said in the petition is true. If they can't do this, then the case is dismissed. You then have to prove that your defenses are true. You can do this in a lot of ways. Most commonly, you'll use documents and testimony. Documents is really broad. It covers pretty much government records, text messages, photographs, video footage. Testimony is when you or a witness go in front of the judge and truthfully tell facts that help prove that your own case is true with the landlord's is false. So, for example, when we're talking about succession, you would use testimony to establish the fact that you were living with the previous tenant for 2 years, that they were a family member to you, things like that. At the end of the trial, the judge looks at the evidence and makes a decision. The judge can either dismiss the case, enter a final judgment against you, which may or may not be stayed, which means that it's paused to give you time to pay or give you time to move. Or the judge could rule in your favor on some defenses, like granting you a rent abatement, but not dismiss the case entirely. So that might be a situation where the judge says something like, yeah, based on this testimony, I'm going to award you a 30% rent abatement, but you do have to pay that 70% by X date. Okay, next slide. I think there was one more. I think there were two. Another slide. I think there was one before that. So settlement or trial. If you settle your case, you are giving up your right to a trial. This is something that the judge will also say to you whenever they're talking through a stipulation with you. It is possible, though, that you might get a better outcome in a settlement than you would at trial. If you lose at trial, for example, you might only have 5 days to pay what you owe, as opposed to like 30 or 60 days to pay in a settlement. On the other hand, if your landlord has made a serious mistake in their case, or if you've saved all the money that you owe and you have it, you're just withholding it, you may just want to go to trial, because then you'll be in a stronger position than the landlord will. Ultimately, there isn't a right answer for every case, and you can even settle in the middle of trial. All right, restoring the case. If you don't do what you agreed to, for example, if you miss a pay date, what happens next depends on the terms of the stipulation. If you didn't agree to a final judgment, your landlord will ask the court to restore the case. If you did agree to a final judgment, you need to file an order to show cause, which we call an OSC for short, to ask the court to give you more time to pay or move. You need to show the court that you have a good reason for not following the stipulation, which is called good cause. If your landlord doesn't do what they agreed to, you can ask the court to restore the case and order your landlord to follow their end of the deal. For example, if your landlord hasn't done repairs, you can bring the case back and say, Judge, I want you to issue an order for my landlord to correct this. Here's some examples of good cause. It's not a complete list, but here are some things that both I have brought up a lot and I have seen brought up a lot. Your landlord was the one who messed up. The reason that the payment is late is that they didn't provide documents, they didn't cooperate with HRA or something like that. Another one is that you and your landlord did what you were supposed to, but a third party isn't doing their job. The very, very, very common situation if you submitted everything for a one-shot deal, but HRA hasn't made a decision. The next one is some unexpected hardship came up that you just didn't know would happen, like someone else lost a job, you had to go to the hospital, there was an emergency or death in the family, and that just set you back on your ability to pay rent. You can also point out whether you would suffer hardship if you were evicted. If you're a long-term rent-stabilized tenant, if you're elderly or disabled, if you have minor children in the household, if there isn't anywhere else you could go or anyone else you could stay with, you should point those things out. Also, if you have paid some of the money you owe, or if you've been paying ongoing rent, you should point that out because the judge will say, well, at least the landlord's getting something, so it's not like he's just sitting there. The timing of this. If you didn't agree to a judgment, then you might want to wait for your landlord to make the first move and restore the case, because your landlord might just not do that for months, which gives you more time to pay or to move or do whatever you need to do. If you did agree to a judgment and the pay date or the move date passes, go to the clerk's office like immediately and file an order to show cause, like right after you receive that notice of eviction. If the order to show cause is signed, it'll pause the eviction process until the judge makes a final decision about whether or not to grant you more time. If your landlord didn't follow the stipulation, you can either bring that up as a cross motion if they try to bring something against you, or restore the case yourself. Default judgments. This is what we talked about a little bit earlier with if you don't show up at court, the judge may enter a default judgment against you, which will grant the landlord what they were asking for in the petition. To vacate the default judgment, you need to file an OSC. You need to say both like why you missed the court date, which is like you never received the court papers, or there was some kind of emergency that caused you to miss the court date. And you also need to say that you have defenses the same way you would in an answer. If you can do those two things, if you can show an excuse, and if you can show that you have defenses, a lot of the time you will get the default vacated. So after you submit your OSC or the landlord submits their motion, the judge will read through it. The judge will either approve it and give you a date and time to come back to court, deny it and give you a reason why, refuse to sign it but not deny it, or tell you to withdraw it and file it later. Sometimes judges will do this, like I've seen this happen before, like when a pay date is coming up and is close and someone's worried that they're not going to be able to make it, and they file an OSC, but the judge says, you never know what's going to happen. Why don't you just come back and file this after the pay date's passed? That definitely happens sometimes. If you're filing an order to show cause and it's approved, you'll get 3 copies, one for you, one for the landlord, and one for the marshal. So you want to follow the instructions for sending the papers to the landlord and marshal. When you come back to court, you and the landlord's attorney will discuss the motion or OSC and see if you can negotiate a new stipulation. If you can't, you go before the judge for a hearing. When you're there, explain what's happening in your case as clearly as you can and bring any documents that you need with you. The judge will either grant or deny that request and will give you a reason for that decision. Next slide. If the judge gives you more time but you're still unable to pay or move, you can file another OSC. There's not a legal limit on the amount that you're allowed to file, but you will again need to show good cause. You also will need to bring proof that between the last court date and the time you're filing this OSC, you've been trying to do your best to pay or move. So like keep records of any communication you've had with HRA or Homebase, anything you've done in terms of apartment searching, just keep receipts, keep track of everything, just log everything away, like you would if you were a petty teenager and you wanted to like post an expose about someone online. Like use that mentality. The more OSCs you file, the harder it may be to show that you have good cause. In my experience, for example, I will say like if someone needs more time to pay and it's the first time, the judge is most judges are, unless you have really been doing nothing and haven't even applied for a one-shot deal, most judges will probably grant a first order to show cause. After that, it gets sort of progressively harder. If the judge denies your order to show cause because you didn't present enough proof, or if you didn't explain clearly enough, you can file another order to show cause and provide more proof. You can also appeal the judge's decision by asking the appellate term, which is the higher court, to sign your OSC. You should go to the help center at the housing court to learn how to do this. And they can explain the procedures more clearly. You can also go to the housing court website and look up the appeal process there. All right, just a couple closing notes. The first one is about judgments. Judgments may appear on your credit report. If you do get a judgment entered against you, ask for it to be vacated when the money is paid. You may have to go back to court and file an order to show cause to do this. The second note is about one-shot deals. So I saw some questions about this in the Q&A already. According to regulations, HRA is supposed to process one deal applications within 30 days. In reality, at least at this moment, HRA can often take like 10 to 12 months to do that. Everyone in housing court knows this, but for various reasons, like landlord attorneys will still not sign stipulations that give you that much time to pay, even if like what actually happens is you do get that long to pay because you just keep filing orders to show cause, and then the landlord's paying more money for you to do this, and it's silly, but unfortunately that's kind of the way it is. So if you want HRA to move, you kind of have to be your own best advocate. Like call, email, visit your local office in person, get everyone's contact information, ask to speak with a supervisor, make multiple copies of the documents you need because HRA will lose stuff. If you run into trouble, call your community board, call your council member, call your assembly member's office, give them the details, explain like what the hardship is. And a lot of times they can step in and kind of nudge people on your behalf. Basically just like find your inner middle-aged white lady with a bad haircut. For more information, again, we have an extensive resources section on our website. You can also view our past webinars there and on YouTube. Housing Court Answers also has resources for tenants as well as a hotline at that number. The hotline is open from 9 a.m. to 5 p.m. And now we'll get to questions. Now we'll get to the rest of the Q&A.
Okay, thank you, Abigail, again for all that information on the housing court process. We do know it was a lot of information that everyone got at one time, so we will be uploading this on YouTube so you can watch it back. If you need to like stop, reread a section that Abigail mentioned, you will be able to do that. Can I sue my roommate in housing court is the first question.
Yeah. Yes, you can. It's kind of a different process, and it depends on like, is this a roommate? I mean, a lot of it's going to depend whether the roommate is another tenant on the lease or if the roommate is subletting from you. If they're subletting from you, they still have what's known as squatter rights. But yes, you can initiate actions against roommates. It's different from the proceedings that I've been talking about here. If you would like, I can send you some resources and research about that, like after the presentation, because it's a little bit of a long topic.
Okay. That was an anonymous attendee, so if you would like to reveal yourself, we can, send you some more information on that. The next question is my deceased father, landlord, have taken my dad 3 times for non-payment since 2023, and the last one was May 5th, 2025. In those hearings, as a son to my deceased father, I have to answer on behalf of my dad because I'm living at living at the apartment, but also the landlord who takes my father to court will make a motion for discontinued without prejudice. So this time I have to ask the court attorney what's going on, and she told me he is trying to bring me for a holdover.
Yeah, he is. So this is another case where you want to assert succession rights, and you want to do that soon. Write a letter to your landlord saying that you are your father's son. You were living with him for assuming that you were living with him for 2 years before his passing, and that you are now asserting succession rights. Get that letter notarized, send it to your landlord by certified mail. Then you can also go to DHCR and file succession rights there if your landlord is not willing to acknowledge you as the successor to your father's lease. So yeah, assert succession rights right away. If you're in court right now, honestly, I would ask the judge for sanctions against your landlord and their attorneys for continuing to bring meritless proceedings when they know that the tenant of record is deceased. Like that's sanctionable. That is the lawyers should not do that, and they should have to pay a fine.
Right. Exactly. The next question is from Javier. I was in court for holdover, and I represented myself via pro se. And after 4 court days, the petitioner withdrew CPLR 3217, relatory eviction. How can I file harassment?
Okay, so that's what we discussed earlier. You can file harassment in the HP part. So the her, again, I'm not sure if we have resources on harassment. Do we have past webinars on that, Jakari? Do you remember?
We do. So if you visit our YouTube, Javier, we do have a webinar on landlord harassment.
Yeah, but you should go to the court. So, but yeah, you should go to the help center at court and say that and just explain that your landlord was doing a retaliatory eviction against you and you want to file a harassment case.
Okay.
Okay.
The next question we have is in Spanish. Can we have Nathan? Are you able to read?
So like I explained, there is a right to counsel law. If you make 200, if your household makes 200% of less of the federal poverty line, you do get access to counsel. You may or may not be able to get a lawyer to fully represent you if you're in court. You should absolutely ask for one. On your first appearance, you should absolutely ask for right to counsel. There will be someone in the courtroom. You can talk to the legal providers who were there that day. They may or may not be able to take your case. They can probably at least provide you with advice. You can also ask to come back to court another day. So in between, you can look for a lawyer.
Okay. I filed a DHCR form for a refusal to renew rent stabilized lease. I received a docket number and a docket number for DHCR report decrease of services 4 months ago. How long to get results from DHCR?
A lot longer than 4 months, unfortunately. DHCR moves slowly. So you can always call and sort of ask about the status of your case. but DHCR can take years and years and years. The presentation slides, I think, are going to be, or sorry, please read it.
Before we get to that one, good evening. What about if court papers are taped up at the entrance of the building where other tenants may read court papers?
Um, so technically they should not do that. There's conspicuous service is supposed to be like on your own door or underneath your own door. You should raise that as an objection, and say that you were not properly served because it was taped on the public building.
Okay. Leslie, yes, I will send the slides to you. Can the landlord make illegal changes on DHCR report? That is not true, like changing dates of tenants' actual move date.
Nope, and you should file a complaint with DHCR about that if they're doing it.
Next question. During lead abatement, possessions and rent stolen, received police report over 1 year have, okay, that wasn't a question. How many times are you allowed to reschedule a court date due to no representation?
It really depends. Most judges will let you do it at least once. Honestly, if you keep they after that, it kind of depends. If how sorry that you can make them feel for you. If your case is, it also kind of depends on your case. If your case is something more complicated, like if this is a case like we talked about earlier with succession rights, the judge is probably more likely to be like, yeah, you should really have a lawyer for this. If the case is something that's a little simpler, like it is a case where you fell behind on rent and you just need more time to pay it, the judge may not grant those adjournment requests as much.
Okay. Once a stipulation is signed by the judge and all parties agree, can the landlord come back later and say the stipulation is wrong?
They can. They can. There are. I mean, you can also go back and say a stipulation is wrong. It's harder for the landlord to say that a stipulation is wrong because the landlord is almost always represented by a lawyer. It's a little easier if you are not represented by a lawyer to say that there's something wrong with the stipulation, just because as a non-lawyer, you're not expected to know these things. If you are a lawyer, then then judges kind of expect you to have gone over things already and like not have made a mistake. And if you made a mistake, that's on you.
June Moses says, thank you very much for this presentation. It was very informative. Javier says, thank you both for your professionalism. We have another question in Spanish. It's kind of long. Nathan, are you able to read this one? Okay.
Is there? Okay. Um.
Um,
So.
Abigail, did you get anything from that, or you need more?
All right. So. Okay. So it sounds like what she's probably done is taking you to case on a holdover. Like it mentioned a little bit earlier with good cause eviction, co-ops are a little bit tricky. They are not as protected. Co-ops are not as protected as other kinds of buildings. Although you should still look and see if your building, if the co-op is rent stabilized or if it's being sublet, or because there might be some defenses there, but unfortunately, if you're unfortunately co-ops are like a little bit harder in terms of raising defenses. Um, you you should raise the issue about the repairs that were never done. And if you're currently having trouble paying rent or finding employment, like I am very sorry to hear that. There might be ways that you could get forms of public assistance to help you out. I would definitely look into that. Just because, like, it's at some point, if you do stay, you are going to be expected to pay at least, again, at least a portion of the rent, even if you would end up getting a rent abatement. So just make sure you plan for that.
Okay, next question. Should I wait for them to take me to court or should I initiate?
Um, Honestly, because of the thing that we're talking about with retaliatory eviction, I would take them to court first. Then, if they take you to court, you have a very good defense, and a very good presumption that they've done it because you sued them. And then they're going to have to rebut or challenge that presumption. So I would take them to court first.
Okay. Next question is from Cindy in Spanish.
Oh yeah. Call the court. In that case, I would just call the court or go to the clerk's office and see what's going on with that. It seems like you're a Spanish language speaker. They always have people who speak Spanish there. So just tell them the case was dismissed. Go to that NICEF website, see if you can look up your case, and they might have an order there where the judge, if they have an order there where the judge says it was dismissed, print that out, and show it to the clerk.
Okay. Um, One more question that I was asked at 8:23, Nathan, if you could read that one.
And I'm assuming you have a court date tomorrow.
Right.
In that case, in the morning, again, I would call the courtroom if you have a courtroom or the clerk's office if you don't. Explain the situation that your husband is not able to make it to court and that you can't go in his place for those reasons and ask for an adjournment.
And then one more, Nathan, the last one.
So, actually, if you go to the websites I mentioned earlier, HPD and Who Owns What, they can tell you whether whether your building is rent stabilized or whether units in your building are rent stabilized. If you're curious about the status of your own apartment, I would go to DHCR, because there are sometimes sometimes entire buildings will be rent stabilized, sometimes some units will be, but others won't be. So to be extra sure, go to DHCR and ask for a copy of your rent registration history.
And joining and participating. And I hope this webinar was helpful for you. I'm going to put up a quick poll so we can know how the webinar went for the attendees that are here. So if you could take some time to be appreciated. I want to thank our interpreter, Nathan, for joining us tonight, interpreting this whole webinar in Spanish. And I hope to see you all next week at our next webinar on estate planning. I hope everyone has a wonderful night.